Good evening and welcome to this special board meeting of the Akron Public School Board on Thursday, April 18, 2024. The first item on our agenda is the appointment of Mr. Alexander as our treasurer pro tem and to do roll call. Is there a motion?
So moved.
It's been moved by Vice President Jackson. Is there a second?
I'll second.
Second by Member Hall. Is there any discussion? Seeing none, roll call. Mr. Alexander?
Ms. Autry?
Yes.
Ms. Hall?
Yes.
Ms. Jackson?
Yes.
Dr. Molnar? Mr. Perry? Ms. Sykes?
Yes.
4 present, 3 not present. Oh, I'm sorry, Mr. Alexander. Yes. 5 and 2.
Thank you. Next is our Pledge of Allegiance. Vice President Jackson, could you please lead us? Thank you.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
There are no requests to address the board at this time, so we're going to jump right into our main topic here, which is our professional development. And again, I just want to thank my colleagues for just agreeing to continue to invest in ourselves so that, again, we can be the best version of ourselves. So at this time, I will turn it over to Attorney Mark Jackson. Thank you and welcome.
Good evening. Through the board chair, board president, to the board and the administration, I appreciate you having me here again. This is part 2 of our presentation on parliamentary procedure, Robert's Rules of Order, and conducting of board meetings. I'm Mark Jackson from the law firm of Pepple and Wagner, and had the pleasure of presenting to you the remainder of our materials. We started this presentation, part 1 was last month, and we're going to be working from the same materials. Before I turn to the materials, also at your place is a 1-page sheet. We had some questions that were kind of lingering from the first session that we had, mostly dealing with agendas and how timing of agendas, consent agendas, how the agenda is prepared. So this is a summary of what your existing board policies say, and there also are some considerations, recommendations that you may want to explore with your policy committee and possibly make changes or updates or to set some guidelines. So just to go over these briefly, I'm going over the third bullet point here, policy number 01651, dealing with regular meetings. So as we discussed at our last session, generally under Robert's rules, it's the board chair, board president's obligation to prepare an agenda. You have delegated that authority under your board policy to the superintendent. Superintendent then creates that agenda in cooperation with the board president, so that the business coming before the board would be compiled through the superintendent. From there, there is some references to when materials or items need to be provided to the board, which is 7 days in advance. There was there isn't a distinct directive as to when board members that want to put something on the agenda have to submit that. So obviously you have a 7-day deadline for when the agenda goes out to the board ahead of a meeting, but there's no timeline. So there's a recommendation at the bottom that if the board is interested in considering having a timeline or deadline, maybe a day or two before that 7 days, you may want to consider that in policy if you want to put something specific in there. That being said, there is a statement in the policy as well dealing with the order of business may be altered and items may be added at any meeting by a majority vote of the members present. So we talked about that as well. Now, if the board itself at the beginning of the meeting approves the agenda for that meeting, then it takes a 2/3 vote under Robert's rules to actually deviate from that agenda. So once you've set your agenda, then it takes a 2/3 vote. But before you set your agenda, if the board wants to add something at the beginning of the meeting or something needs to be changed, you have it in your policy that's allowed to occur. So also, there's a reference to consent agendas. The use of consent agendas is explicitly stated in your policy. We talked about consent agendas and what types of items can be included in a consent agenda. It's not a specific reference right now, so you may want to consider some language that says consent agendas could be used for routine, non-controversial, or procedural decisions or technical corrections. Right now it says technical corrections are what should be included in or what consent agenda could be used for. So that doesn't mean it's the only thing that a consent agenda can be used for. There's not going to be a violation if you use a consent agenda, but to have some more authority and to have some more directives about how your consent agenda operates, then you might want to consider that in committee as well. So those recommendations or considerations are included at the bottom of this page for your future discussion. So moving on to the actual materials themselves, we were on page 21 is where we left off, and we had just finished discussing various types of motions. Now we're moving towards voting. How are votes conducted? Unless a particular statute requires a specific voting method, the board may use its own discretion in determining the method it will use, such as a voice vote, show of hands, or roll call. I will note that there are some times when a roll call vote's required under Ohio law, so a lot of times boards just implement, we're going to use a roll call vote on every vote rather than voice vote. So that there's not an error that might occur. Use your discretion as to how you want to handle voting. But in those items where a roll call vote is required, those will need to be included. For instance, if you go to executive session, a roll call vote is required under Ohio law. A majority vote is your standard passage for most of your items. The basic requirement for approval is unless there's a law or rule that deviates from the majority vote. There is a attachment to your materials that I provided that is Board Policy 0167. This identifies a lot of those votes where something besides a simple majority would be needed to pass an item. So the topic is listed in there, and there's also statutory references to you. You already have this in policy, so reference your policy if there's a question as to whether something needs a majority vote or a 2/3 vote or a 3/4 vote, because sometimes it's set by rule, sometimes it's set by statute. 2/3 vote, parliamentary procedure, some items or a law may require a 2/3 vote. When the term 2/3 vote is unqualified, it means at least 2/3 of the votes cast by persons entitled to vote at a properly called meeting. So sometimes your 2/3 vote involves 2/3 of you that are present, and those are the ones that are under Robert's rules. Sometimes a 2/3 vote under Ohio law requires 2/3 of the entire board to pass an item. So you would need, if you've got 7 members on your board, you need the 2/3, so 5 of the 7 to vote on those items that are required under Ohio law to pass the 2/3 vote requirement. It is important that the board president restate a motion before a vote on the item. So typically, if there is some discussion, if there are changes to what item is before the board, it's recommended that you would have the board president clarify so that everybody knows what they're voting on. If there's been an adjustment to the language for whether it's a motion or whether it's a resolution, whether some changes have been made, so that people know what a yes vote means and what a no vote would mean. Each board member is entitled to only 1 vote on a question. That's, sounds pretty simple, but there are no proxies. You can't say, I'm going to, for this meeting, delegate a proxy. You all are elected board members for, the city of Akron and the folks that attend Akron Public Schools. So your vote is important. You can't just say, I'm going to delegate it to another board member for a meeting because I'm not going to be present, but that person speaks on my behalf. That's not allowed under Ohio law. When voting, members should not state the reasons why the member is voting for a certain way. That should be discussed in deliberation. You should deliberate, and then once, if you are doing roll call and they're asking, for your vote, yay or nay, yes or no, however you want to submit that vote, that's all that needs to be said. You don't need to justify your reasons for it at that time. That should have been done earlier during deliberation. A member has a right to change his or her vote up to the time the result is announced. So if somebody sitting at the table until the final vote is counted, somebody wants to change what their vote was, they have a change of heart, you can put that on the record to the recording secretary. But once that vote is then finalized by the board and it's announced by the board president, whether it passed or failed, then no changes can be made absent the board itself allowing for a change in that vote, so to be changed on the record. So that would you'd have to open up discussion again as to whether a board member could change their vote on that. And then again, that would be subject to your parliamentary procedure of a motion to change a vote and second, and then discussion in those situations. After the vote is conducted, it is the duty of the board president to confirm the vote and declare whether a motion is passed. So using the term carried or passed versus whether it failed is the correct terminology. Abstentions always tend to be an area where board members, whether they abstain too much or not enough. Generally, under Robert's Rules of Order, only under limited circumstances should a member abstain from voting. Typically, the abstention should only occur if there's a actual conflict of interest for the board member that could be considered a violation of the ethics law or another law. If it's a controversial topic and you don't want to put something on the record, or you want to abstain, generally that's not good procedure or seen as appropriate under Robert's rules. Normally, a board member should attempt to cast a vote on every subject unless there is a conflict of interest. And we're going to talk about what conflict of interest may occur further at kind of the conclusion of my presentation. Robert's rules say that no member should vote on a question in which the member has a direct personal or pecuniary interest not common to the other members of the organization, so an ethical conflict. And then there's also Ohio law that deals with ethics that would specifically prohibit a vote at a certain time. Yes, I am at page 22 at the bottom. Yep. And this is under I number 2 is what I'm about to discuss. So Robert's rules advise that voting on a question of direct personal interest does not mean that a member should not vote for himself or herself for an office or other position to which the members are generally eligible. So if there's a vote on who should be board president, there's nothing that prevents a board member from voting for themselves in support of, if somebody recommended them to be a board president, board vice president, whatever the office is, that's not going to be a conflict of interest. Just because you voted on that office doesn't mean you've done anything that violates ethics laws or violates Robert's rules of procedure. So that is not something that would be considered a direct personal interest because you're not getting any extra compensation for serving as a board president, for serving as a vice president. It's seen as you're still equal in the remainder of the board. You still have the same duties and responsibilities. Moving on to postponing versus tabling of an item, and this often gets confusing for people. Boards, we see this as one of the things that we get questions on it a lot because people just want to say, we want to table that, we want to table it to the next meeting, we want to table it to later in the meeting. Tabling is only used in certain situations and oftentimes postponing board action is something that is actually what everybody's trying to accomplish instead of actually tabling a matter. So this is something that, if you use this correctly, it's a good part of procedure that can be incorporated into your meetings. If a board does not wish to proceed with a formal vote on an agenda item, the following explains the differences between postponing and tabling. So postponing an item is if a board does not wish to proceed with a vote on an item, the preferred procedure is to pass a motion to postpone that item. Items may either be postponed until a specified time, which could be later in the current meeting, at a future meeting, 6 months from now. If you want to talk about it in the July meeting, you can postpone it. You can set when that is postponed till, or postpone indefinitely. If there's a question that you just don't, or a motion or a resolution that we don't know when we should vote on it, we can postpone that indefinitely. You would have to then take that, take action to consider that motion that's been postponed, but at some point in time, postponing it indefinitely doesn't mean that it's going to die on the table, as we're going to talk about with tabling. So when a board agrees to postpone an item to a particular time, the board has ordered the item to appear on the agenda automatically at that time. So if you've decided you're going to postpone something till the next meeting, it automatically appears on the meeting agenda. You don't have to then say, have a motion to consider the item that was postponed. It will automatically appear. If you postpone something to later in the meeting, then it will automatically appear. You don't have to move to take the motion off the table. It's been postponed until the end of new business, the end of old business, wherever you postpone it till, it automatically comes back up. Postponing indefinitely, if the board postpones an item indefinitely, the item cannot be taken up again at the same meeting or a future meeting until the board takes action to reconsider that item. So to postpone an item indefinitely, the motion to postpone must be seconded and is subject to debate and requires a majority vote. So if you decided to postpone something, we don't know when we're going to consider in the future, but it was something that we did have on an agenda, and we postponed it indefinitely, then we need to bring a motion to reconsider that item to bring that back up in whatever meeting in the future that we're going to consider again. It's really not proper procedure to bring that as new business because it's something that we've already considered once. So that's kind of the difference between postponing indefinitely and postponing to a specified time. Now, placing an item on the table, under Robert's rules, tabling of an item should only be used in rare situations where the board needs to lay a pending item aside only temporarily when something of immediate urgency has arisen or when another item needs to be addressed before consideration of the pending item. So if you have something else comes up, that's when your motion to table is most appropriate. Tabling an item then requires you to take action to remove that item from the table to then consider it. So let's say you have an item for discussion, there's an emergency situation occurs, we need to evacuate the building, we would table that item. Or if you have something on your agenda, you say, well, there's something later in the agenda that may need to be considered. We can table that, but it needs to be done temporarily. It's something that we just need to excuse this for an urgency or an emergency type situation. That's when we table something, and then we would take it off the table later. So once tabled, a subsequent separate vote of the board is needed to remove that item from the table before the item can be further considered by the board. You don't have to debate taking something off the table because it's already been tabled, but you do have to take some sort of action to take the item off the table and bring it back for consideration of the board. When you do bring it back off the table, whatever, if you were deliberating on it, you can then continue deliberation on it. If you already held your deliberation on it, then you tabled it, then there may not be need for more discussion. You can then move to vote on it. Again, you're going to have to deal with the situation at the time as to what the status of that item was, as to what portion of the procedure you're under. So if an item had just been brought up, we decide to table it, then you would then decide whether deliberation needs to occur on it still. Items cannot continue to be tabled over a period of multiple regular meetings. If an item remains tabled at the conclusion of the meeting, the item then should appear on the next agenda. You still have to remove it from the table if you want to vote on it. that at the next regular meeting with the designation that the item was tabled. So there should be something on your agenda that says, here's the item that we were considering, in parentheses behind it, tabled, so that the board knows to take it off the table if they want to consider it. If the board fails to take that item off the table or vote on the item by the conclusion of that subsequent meeting, so if a tabled item appears on your next agenda as tabled, you decide not to vote on it, the item automatically dies. So it wasn't taken off the table, it wasn't postponed, it dies automatically by operation of Robert's rules, so that it won't appear on any future agendas. The treasurer should note that in the minutes that the item died per operation of Section 17 of Robert's Rules of Order. There's some other ways you can note that on your minutes, but if something was on the table, it doesn't get brought back up, it doesn't get removed off the table and considered further, then that subsequent meeting, you would have to start fresh with that motion again, rather than trying to bring something off the table and if it happened on a third meeting. So any questions about that? It's somewhat confusing, but the terminology of table versus postponing tends to, we get a lot of questions on it from at Pepple and Weiner at least. If not, we'll move on to discussion of officers. So this is your president, vice president. How do those positions get appointed and voted on and approved? So nomination of an individual to serve as an officer. The traditional method for nomination of a board member is to serve as an officer. To serve as an officer is under the procedure of nominations from the floor. Typically, a board president or chair calls for nominations at the time established by rule. Oftentimes, this happens at your organizational meeting in January. Are there nominations for the board president? It kind of opens up the floor to the remainder of the board. If somebody has a nomination, they make the nomination. And then the board members can continue to nominate while it's open, rather than voting on that individual right then. You would have some time for others to be nominated. And then once nominations have been made, then it goes to a vote. So no second is required, but sometimes one or more members will second a nomination to indicate endorsement. But because you seconded somebody as a nomination doesn't mean that that's the person you have to vote for whatever the office is. No member may nominate more than one person for the office until every member wishing to nominate has had the opportunity to do so. When no other members make nominations, the board president declares that nominations are closed and the election is placed to a vote. In ordinary societies or smaller boards, speeches or debates by members to advocate for candidates are not common. So it's up to what conventional procedure you use here, whether you need to have a speech on behalf of one person versus the other. Unless the board has established specific rules for the election of officers, voting occurs in the standard manner utilized by the board. Board members are requested to vote for one of the candidates. Where a candidate has attained a majority, the board president declares that candidate elected. So automatically, if there's 4 votes, a majority has voted on behalf of that person for the office, that person is declared the officer. Where no candidate has received a majority of the votes cast, the board president announces no election. So oftentimes you might have 2 people vying for a position, they don't get a majority of the board, then that office remains open until a majority on the board will vote for the office. I've had boards of education where it's taken 4 or 5 rounds to figure out who's going to be the board president. It's not all that common, but sometimes it does happen, and we have to deal with it from that situation quite often. So an election should be completed at the session at which it is taken up, unless it is impossible or impractical to do so. So if one of the items of your organizational meeting is to appoint a president and a vice president for that year, we shouldn't be tabling it. We shouldn't be postponing it. It should occur at that meeting unless there's an extenuating circumstance as to why those offices should be appointed. An election to the office becomes final immediately if the candidate is present and does not decline the office. So if somebody gets voted to be board president, you have the opportunity then to be appointed board president, take the chair, and unless you decline the office right then and there. If you don't decline the office, that person becomes board president. You would need to resign from the position of board president to remove the person from office or have that person no longer serve as board president. There are some, this is on page 26, principles of holding an office. I'm not going to go over these in significant detail, but I will highlight that an office carries with it only the rights necessary for executing the duties of the office. It does not deprive the member of the public body rights as a member. So if somebody serves as a board president, they're still a member of the board. There are some practices that have been put in place with some governing bodies with board presidents that, the board president isn't supposed to raise a motion, those types of things. On a board of education, elected board, the board president, the board vice president, just because they are an officer, they still have the equal ability to make a motion. They are not deprived of that, like in some other societies where that might be a common practice. Oftentimes, the bylaws or custom of a body contain a practice, as I said, that no person shall be eligible to serve consecutive terms in the same office. So sometimes, they want to rotate board presidents. There's nothing in Robert's rules that say your board president this year can't be the same board president next year. If there's a consensus, that person, receives the nominations for board president and gets appointed, there's nothing that prevents them from doing that. The presiding officer of Board of Education is the board president. The presiding officer of an organization should be chosen principally for the abilities to preside over the body. And there are some items. We've gone over a lot of these responsibilities of the board president, and those are again listed on this, so I won't continue to I guess, state what I've already said. When the board president is absent, if the board president is absent, or if it is necessary for the president to vacate the chair during a meeting, the vice president automatically takes the chair and presides over that meeting for that purpose. So there's already somebody in place. If the board president and vice president are not present or must vacate the chair, the board should appoint through election at that time a chair pro tem to serve until the board president or vice president return to the meeting. If you have a second vice president, sometimes that person would serve, but generally boards of education typically only elect the board president and the board vice president. There's also the thought that, or some boards of education put in practice that the vice president automatically should be the next board president. There's nothing requiring that under Robert's rules or under Ohio law, so there's no entitlement for a board vice president to automatically attain the office of president, the following year or the following term. That is still subject to vote at the next organizational meeting. So that may be a custom, but it's just a custom. So you aren't bound to it, but it also creates a little bit of order too if that's how this board likes to operate. So that's subject to the discretion of the board, but it is not something that's set by any parliamentary requirement. Recording secretary is the next office that we'll talk about. The recording secretary of a body is responsible for keeping a record of all the proceedings of the organization, so the minutes, and the recording secretary, there's no requirement that the recording secretary be a member of the board. Rather, for most boards of education, your treasurer, your fiscal officer, even somebody in the treasurer's staff may serve as a secretary pro tem at times. So the recording secretary is the one office that doesn't have to be an elected board member and generally isn't when it comes to boards of education. The recording secretary keeps the board's official membership roll and calls roll during the meeting where it's required, makes minutes and records available to members upon request. So it also serves as the recording secretary as the records custodian. Under Ohio law itself, the district's records custodian is responsible for maintaining records of the Board of Education and responding to public records requests. So if your treasurer is also designated as the records custodian, then that person's also responsible for providing those responses to public records requests under Ohio Public Records Law, which is Revised Code 14943. The recording secretary generally sends out to the membership any required notice of each meeting and to conduct the general correspondence of the organization. Also signs off on certified copies of minutes or resolutions. They basically serve as the person that verifies the actions of the board and the official documents of the board. This public notice also, again, is the recording secretary under Ohio law, Ohio Sunshine Law 12122, the Open Meetings Act. The recording secretary is responsible for publishing the public notice that goes in the newspaper and on your website and various other places that would need to be posted. In the absence of the board president and vice president to call the meeting to order and preside until the immediate election of a board president pro tem, your recording secretary would be the person that steps in to that role, at least until a board president pro tem is appointed. Again, appointment of a temporary recording secretary. We happen to do that today. There's some sample motion or resolution language here. When the secretary or clerk of the board is absent, the board is required to elect a secretary pro tem to serve in the absence. So we use a parliamentary procedure right at the beginning. Well done. Filling of an officer vacancy during a term. So at times, the board president or vice president may resign the officer position midterm, and another member will need to be appointed. Again, if the board president steps down, typically the vice president, by operation of Robert's rules, assumes the board president's chair. If the vice president steps down, then you would have to go through another election to appoint a new vice president. And so that's, there's some succession when it comes to board president versus vice president for those that are in for that one term. Moving on beyond officer positions, we'll talk about minutes a little bit. The official recordings of the proceedings of a Board of Education are called minutes. The minutes should be kept in a substantial book or binder. As we are moving to a lot more electronics, how we maintain, not as much paper. If the minutes are being maintained in electronic format, we need to make sure that those are backed up, because Ohio law requires minutes to be maintained indefinitely in a format that is accessible to individuals. So if we do have an electronic database where the official minutes are being maintained, then we want to make sure that everything's backed up so we can comply with Ohio law. That's the minutes as it works generally. The contents of minutes require that minutes should contain a record of what occurred at the meeting, which is somewhat vague. So Ohio law, and there's been some case law interpreting that. Basically, the directive is minutes must include enough facts and information to permit the public to understand and appreciate the rationale behind a public body's decision. So when you're creating minutes, the objective is so that there's some basis behind what the action was. If somebody, we don't have to have a verbatim record. It doesn't have to be a transcript of the proceedings, but there needs to be some. If one board member said, I'm voting for this, or I support this motion based upon this reason, there might be some notation in the minutes so that the public can understand why that decision was made. Minutes are a requirement under Ohio's Open Meetings Act and also must be disclosed under Ohio's Public Records Act. So not only are they governed by how Robert's Rules requires them to be maintained, it's also a requirement that if they're subject to inspection or request or review under the two laws that make up Ohio's Sunshine Laws. We're next moving on. This is page 30 of your outline to committees. A committee is a body of one or more persons elected or appointed by an organization to consider, investigate, update, or report on certain matters or subjects, or to do all of these things. Committees created by the board report its findings to the board. Generally, under Ohio law, a committee does not have authority to take action on behalf of the board. So when you have a committee, ultimately the board is the one that makes the decisions. If you refer something to committee, the committee can't be delegated the authority to make a decision on behalf of the board. That the committee is going to make a report recommended to the board, and the board is going to adopt that report, adopt the recommendation. It just depends what action has been requested. Committees established by a Board of Education are subject to Ohio's Open Meetings Act. So if you have a committee, even if the committee is comprised of less than a majority of board members, because the committee was created by a public body, the committee should also adhere to Ohio's Public Records Law, Ohio's Open Meetings Act. So if a committee is meeting, that committee should also notice that it's having a meeting. That meeting is open to the public. That meeting should be conducted in a similar manner to a board meeting. It doesn't have to be as strict because there aren't Robert's Rules of Order appointed to that under policy that aren't dictated to I guess, govern the operation of that committee, so it can be a little less formal. But again, you're going to want to maintain minutes for those committee meetings, what was discussed, what items are on the agenda, what recommendations were made, what information was going on in the committee. Generally, individuals appointed to board committees serve on one-year terms on the committee. That's set by your board policy. So when you have a committee, again, at your organizational meeting, or if you create an ad hoc committee, the individuals that are appointed to those committees serve for 1 year. Ordinary committees are of two types: standing committees and special committees. So your standing committees are your committees that go on indefinitely. You always have these committees. Boards of education often have a finance committee. They often have various student committees, various items that a Board of Education considers routinely. They often will create a committee that addresses that. An insurance committee in some school districts. Just depends what items are important to that school district to create a committee that's a standing committee. Special committees are committees that are created only for a specific purpose, that are given a directive, maybe to find out the answer to a problem. If you have a specific building that you're looking to construct, oftentimes there might be a special committee that may look into how the items that are necessary for that specific building. If you have something that you're looking to create and want further information or investigation into it, then a special committee for that purpose may be an advisable way to have that information presented to your board. Methods of appointment. So Robert's Rules says there are various ways for committee appointments to occur: by election of the board, by nominations to the floor, nominations from the chair. Your board policy sets that appointments to committees are made by the board president. So under board policy 0155, the board has established various standing committees. The board president is responsible for appointing members of the board to those standing committees. And the standing committees are comprised of 3 members. Under board policy 0173, the board president is delegated the authority to appoint all committees. So the authority goes to the board president to determine which board members should serve on those various committees. It's not something that would be subject to a vote under your normal operations of a board meeting. Conducting business in a committee. Committees operate under the same bylaws and authority and special rules of the board, which may be applicable to them. So if something's been delegated to them, it should serve under those same rules and bylaws and open meetings requirements. A report of the committee is an official statement formally adopted by and submitted in the name of the committee members to inform the board of items addressed, information obtained, or actions recommended. So if they have a directive, they need to report on something, then a report should be presented to the board. It should be put on your board agenda. Maybe one of the individuals, it's a board member that served on that committee, would present and summarize what's in that report to the board during a public meeting of the board. And then the board would then review what that report is. Recommendations of a committee for consideration by the board should generally be presented in the form of resolutions. So if your committee has recommendations, oftentimes that is in the form of a resolution. So in addition to that report, if there's an action item that comes out of committee, normally the committee would also submit with that report a resolution. If you have a resolution, you go through the process of considering a resolution as you would under Robert's Rules that we already discussed previously. If there's just a report, A report of the committee to the board should be presented by a reporting member. Following the presentation, the board may move to take action on the recommendations. Motions to receive or approve a report is not the general way to move to adopt that report. You should use the term adopt on a report. So receiving or approving oftentimes get confused, but under Robert's rules, it's you would want to adopt those reports would be how you should, as a board, move to accept what was presented by that committee member and that committee. If a report contains only an account of work done or a statement of fact or opinion for the board's information, the report should be provided in writing and may be presented to the board during a meeting. However, apart from filing such a report, no action on it is necessary, and usually none should be taken if it's informational only. So if you only are presenting information, providing an update, you didn't have a full report, or the report doesn't make any recommendations, there's no need to take any action. You can just listen to what that report is. You don't need to adopt it. Next item on your outline basically are some summaries of what your bylaws. Each board is required to adopt bylaws that govern itself as an organization. At a minimum, according to Robert's rules, your bylaws are supposed to contain certain things: name of the organization, number of members. I reviewed your existing policies, so there's your references in the policies dealing with each of these items to show that your bylaws are compliant with what Robert's rules requires, as well as Ohio law. Next, I'm going to move into disciplinary matters. So we're going to divide it up into two types of discipline: discipline of a board member, discipline of an individual that may be in the audience, an attendee of your meetings. Always remember, boards of education are comprised of elected individuals, so there are some due process entitlements to somebody that sits in a governmental position. So in a disciplinary situation, if the board is considering discipline of a board member, there also needs to be some due process provided to that board member as well. So the first item we're going to talk about is calling a member to order or removal of a member from a meeting for being disorderly or disruptive. If a board member at times continues to interrupt, is disruptive, disorderly, needs to be brought to the attention of the board, or an item needs to be included in the minutes showing the individual's behavior, then these are the types of steps that you would want to take. Formal disciplinary procedures toward a board member should be generally regarded as a drastic step reserved only for serious situations or egregious behavior. Further, all persons present at a meeting have the obligation to obey the legitimate orders of the presiding officer. So there's a little bit of give and take there. In dealing with any case of disorder in a meeting, the board president always should maintain a calm and deliberate tone. So we've talked about that also, how the board president kind of sits and makes sure that the organization and the board continues to operate in a professional manner. That's a requirement of the board president. If the offense of a member during a meeting is serious in nature, normally the board president should warn that member first. Depending upon the situation, with or without warning, the board president or any other member can call the member to order by declaring that member is out of order. So if there is again, this should be a drastic step based on egregious behavior. If somebody is out of order, it doesn't have to be the board president. It typically would be, but it doesn't have to be the board president to call somebody out of order. Another board member is authorized under Robert's rules to call somebody out of order. In cases of obstinate or grave breach of order by a member, the board president may instruct the recording secretary to transcribe objectionable or disorderly words used by the member for recording in the minutes. So if a board member goes way over the top, starts saying things that are inappropriate, the board president can direct the recording secretary, we want this documented, so please note in the minutes what was said by member XYZ. The board president may not independently impose a penalty against another member. Only the board may do so. So again, this is talking about from the board itself providing due process to a board member to actually discipline one of their colleagues. If the conduct continues, any member can move to order a penalty, or the board president can inquire of the membership what the penalty shall be imposed upon by the member. A vote is taken by the membership on the penalty, such as removal of the member from a meeting. So if somebody is not allowing business to transpire, they keep interrupting, nothing's happening, then the board itself will make a decision on whether that person should be excluded from the meeting, from that specific meeting or not. But again, these are elected officials. There are some minimal entitlements to be able to attend every board meeting. Because you are elected, you're serving on behalf of the individuals that elected you in the community. So when somebody is excluded from a meeting for being disruptive, egregious behavior, then that individual should only be removed from that specific board meeting. If the board president is the subject of a disciplinary proceeding proposed by a member, the board president should relinquish the gavel during that time and until the disciplinary proceedings conclude. So if the board president is the one that's out of order, then that board president, for the time being, should relinquish the gavel to the vice president so that the discipline can be considered. We're at the bottom of page 33. This is permanent removal of a member from the board, and this is statutory under Ohio law. So there's only certain situations where somebody can be completely excluded from the board, from their board position. The first one is excessive absenteeism. This is Ohio Revised Code 33-1311. Any member who fails to attend meetings of the board for a period of 90 calendar days for reasons determined to be insufficient on the affirmative vote of 2/3 of the remaining board members, and this vote is taken and entered into the record of the board no less than 30 days after the period of absence, shall no longer be a member, and his or her office should be vacant. So there's specific criteria for excluding somebody for due to absenteeism if they continue to miss meetings for 90 days or more. There's also a removal for gross neglect of duty, gross immorality, drunkenness, or other misconduct in office, and this again is Revised Code 3.07. This is something that the electors of the school district would file a petition to have that person removed. So proceedings for the removal of a board member are commenced by the filing of a complaint signed by at least 15% of the total votes cast for governor in the district at the last general election with the Court of Common Pleas of the board member's residence. So 15% of the individuals that live in the district would have to sign this complaint. It's then filed with the Court of Common Pleas. The law directs that a hearing on the removal be conducted within 30 days, so that judge will hold a hearing. At the hearing, the judge or the board member can request a jury to make a decision to determine whether the board member should be removed based upon a finding of guilty by misconduct in office. So that's, I can't remember being a school law attorney for 18 years, the last time that I can remember a board member actually being removed based upon a court hearing. So that's very rare, but again, that's statutory. That is something that could occur if there's enough support in the community to remove somebody. But again, the misconduct must be one of these types of items listed: neglect of duty, immorality, drunkenness, or other serious misconduct in office. Turning now to removing an attendee. So this is not a board member. Might be somebody in the audience that won't allow the board to proceed further. They're being belligerent, talking over everything, interrupting. Oftentimes, and we see this is quite common in boards of education at times. Meetings are open to the public, so again, there are members of the public that feel aggrieved for some reason. They want to have their voices heard, so sometimes it gets out of hand. In cases of disorder, removal of an attendee at a meeting can be effected by a ruling of the board president. So the board president normally sits to make that decision. The removed attendee has no right of appeal from an order of the board president. However, such an order may be appealed by a member, not the attendee. That appeal is undebatable, and the board votes as to whether to exclude the attendee from the meeting. So if there is somebody that's being disruptive here, the board president will make the initial decision, say we're going to exclude this individual based upon that conduct. If another one of the board members disagrees with that decision, then that could be appealed. It would have to be put to a vote to the remainder of the board to decide whether that person should be permanently excluded from that meeting by the board president. Again, this is for one meeting only. If you do happen to have somebody that's continually interrupting, then obviously contact board counsel. There are some reasons or bases to permanently exclude somebody from meetings for a certain period of time, 6 months, 9 months. But again, you're weighing somebody's rights to attend an open meeting versus whether their disruptive activities allowed for the board to exclude them for a certain period of time. So I've also cited some case law in this item. There's a 3rd District case. There's also an 11th Circuit case, federal law. So when an audience becomes so uncontrollable that the public body cannot deliberate, it would seem that the audience waives its right to or is a stop from claiming a right under the Sunshine Law to continue to observe the proceedings. So that's kind of one of the statements of a trial court. If the board can't perform its business due to somebody in the audience, then certainly we can look to exclude that person or overall an entire crowd from a meeting so that we can get the work done, because this is a limited public forum. There are entitlements to attend, but there's also entitlements for the board to get their work done. Another statement is finding that there were no First and 14th Amendment rights when a disrupted person was removed from the public meeting. So they were claiming that they have a right to free speech, that they can come speak at a Board of Education meeting as much as they want and say what they want, not necessarily beyond the allotted 5 minutes, or they would want to go beyond their allotted 5 minutes. That person was being disruptive. That person was allowed to be excluded from that meeting because they wouldn't allow the remainder of the individuals that had their 5 minutes left to talk to continue to talk. So once that person had their opportunity to speak and they continued to disrupt, then the board in this case was found to have been able to justify that removal. Another disciplinary type of situation is referred to as censure of a board member. Censure is an official expression of disapproval on the record or to reprimand and admonish a member. So this isn't excluding a member. This is just saying we vehemently disagree with some statement, some decision, some action of a board member. Rarely should this be used, but I have had situations where we've had a board member that there's oftentimes a rogue board member on some boards, and that person, he's going to say what they want to say, even though it's not appropriate. The rest of the board does not agree with what was said. There might be a motion to censure that board member. It's intended to express disapproval for obstinate or grave breaches of order or conduct. The only consequence of a censure is the admonishment or reprimand itself, so it's just something on the record saying that we disagree with that. There's no penalties associated with that. It's just something put into the record. However, an organization has the right to make and enforce its own rules and to require that its members refrain from conduct injurious to the organization or purposes. So if there's something that somebody is doing that is reflecting poorly on the Board of Education, and we've talked about making statements contrary to and those types of things not being taking a stance on something political that's going on outside of the Board of Education business, oftentimes those aren't considered appropriate for what a Board of Education is doing. But in certain situations, if there's somebody out there making public statements in support or in or against something out in the community, and the board itself disagrees with that, the motion to censure to put something on the record might be the avenue to look into. I have some examples, include repeatedly questioning the motives of other members, persisting in speaking on completely irrelevant matters in debate, ignoring the chair's legitimate requests, and so on and so forth. So those are like in-meeting type things, but there's also, if you disagree with something, then the motion to censure might be appropriate. Again, this is a case-by-case basis, depending on what the situation is. And again, you'd probably want to review that with legal counsel to have whatever appropriate information you want to include in any resolution to censure. Yes?
What role does this censoring of a board member play in regards to a board member's First Amendment rights on comments that's not board related, but just some like statements that they may make, personal statements or on personal social media or in another form if they're in other organizations?
So a motion to censure, or I guess a resolution to censure, if one is taken, there's no penalty or effect that it would have on that board member. It may, maybe when they're up for election again, it's brought up that this person got censured by their board 5 times, admonished by their board 5 times because they were, whatever they were posting on social media, if you're disagreeing with that type of thing.
I'm sorry.
Sure.
For clear, I'm saying in lieu to what you explained, the reason for censoring is could the board outside of the setting of the board with anything that's not contrary to, it's not blatant or talking against another board member or anything, if a board member makes a statement of something that, or doesn't even make a statement, or if just has something on in their personal affiliation, or if I'm a member of the NRA, and the majority of the board are like against guns, period, and I make a state or I share information in support of said things, is that a censoring thing? I'm just trying to get some clarity.
I from my standpoint, there might be affiliations like, NRA or other, organizations that the board itself or other board members, I guess, on the board don't agree with that individual's, choice to be a member of whatever that organization is. You would have to determine, is that something that the Akron Public School Board wants to, the remainder of the Akron Public School Board wants to make a public statement about? Do we want to go on the record saying we disagree with this? Is it appropriate? And again, we're kind of guided by, whether this is something that is severe enough to merit a public statement against on behalf of the board. And oftentimes, a lot of times you'll see us censure something happened in the community, okay? And you had one board member out there making public statements that they support whatever that cause is. And they're going on the record out in the public, and they get cited in the newspaper. So-and-so, who's a board member of the Akron Public Schools, expressed their support of whatever this position is. And we, the remainder of the public, of the school board, doesn't agree with that. I've seen, a censure motion or resolution passed in those situations because we don't want to be associated with that or affiliated with that. It would put on the record that that's what, the remainder of the board and who supported that censure motion or not. But again, it's whether the board itself feels so compelled by by whatever that action was, whatever that statement was, that we need to go on the record and oppose that. It's rare. It doesn't happen often. We know a lot of people use social media, and a lot of people say a lot of stupid stuff on social media. That doesn't necessarily mean every time somebody says something stupid or against what our beliefs are, merit a censure, motion on the record for the school board. But there are a lot of divisive issues that do come up, and sometimes a board feels so compelled that we need to put something on the record that we're gonna put a censure motion out there. So I think it depends on the situation. It depends on what the the statement that was made, and it's normally something that's more of a somebody made a statement. It's not necessarily because they were affiliated with an organization that people don't like the whatever it is, the political leanings or the whatever they're advocating for. But it's something that in that instance we don't want to be affiliated with it. We know that person's out there making public statements about it, and we would like to go on the record about it. So that's where you see a lot of censure stuff come in, and I think I've probably only had boards pass 3 of these in my whole time, or at least consider 3 censure motions that my whole time working for Heppel and Wagner. So but it is something that some people just feel so strongly about things that they feel that they should consider it or put it on the record or at least bring it up to the board to consider. So take that for what you will. But I think it's more of let's bring it to your legal counsel, bring it to the administration to decide whether it's something or your fellow board members is something we should consider. A motion to censure requires a second, is debatable, and subject to adoption by a majority vote. So again, this is a majority vote situation to put something on the record for a censure. If somebody is moving to censure a board member, that board member that is being considered for censure has the ability to discuss and debate why they don't think they should be censured or why they're, whatever they did say was appropriate. So, and that should be made part of the record as well. So, this is something where, if you do have one of those motions up for consideration, there will be discussion on it, and there should be discussion on it to determine the board's basis for that decision. Last item, dealing with Robert's rules before we move on to next topic. Do we have another question? Yeah.
Does this only apply to the board members, because you were also speaking about audience too? So board members can kind of state their claim on why they made that comment. An audience member do the same?
An audience member, you have a limited public forum. An audience member has no necessarily any right to say why they should or shouldn't be sent. You're not going to really censure an audience member. You could take an action to express disapproval of whatever that may be, but we're not going to censure is specifically to put something on the record about another board member or something of that nature. So. The last one is rescinding and expunging previous board action. So we previously talked about rescinding board action. So this is the board's already approved something. They've had a change of heart. The board as a whole decides we're going to rescind what that action is. Rescinding and expunging is something that not only are we rescinding that, we also want to make a notation in those previous board minutes that we vehemently disagree with whatever that previous action was. So something that's strongly objectionable. Let's say you had a predecessor board that made a decision that's completely disagreeable to the existing board, the new board that's been appointed. That new board can consider action to rescind and expunge that previous board action. So as opposed to only rescinding, expunging allows the board to make a notation in the margin of the minutes where the original action was taken, noting that the board states that the subsequent action of the board resulted in an expungement resolution. both Robert's Rules of Order and Ohio law does not allow a Board of Education to delete things from their minutes, so you can't go back and take that out. It might have been something that was inappropriate at the time that this board feels completely should not have been passed, and we want to put that on the record, but we can't delete that off that previous board's record. We can only make a notation in the margin as to why, as to the expungement of that item, and then refer to the resolution where the rescission and expunging occurred, so that there will be on the record reasons for why we strongly object to what that previous decision was. Robert's Rules advises that a motion to rescind and expunge should only be used in extremely rare circumstances. So a lot of these items that we talked about, disciplinary matters, they rarely should be used. They're kind of weapons. They're things out there that, save them for decisions and other matters that truly need that type of response, rather than going through and saying, well, that was inappropriate at the time, but it's something that we've dealt with and it's been addressed. Rescinding and expunging follows your normal resolution procedure. It's subject to debate. It's subject to a majority vote. So again, rescinding and expunging is something that would only be used if necessary, if there's something in the record that maybe a previous administration, a previous board did, rather than the existing board, or things have changed to such a certain extent that we also need to put in the record why we feel something should be noted for why it was rescinded. So ultimately, that's where we're at with the parliamentary procedure portion of my presentation. I'm going to turn to discussing the Open Meetings Act, how that may have some implications to parliamentary procedure, and then we're going to talk about some ethics issues. Does anybody want to take, we've gone for about an hour, does anybody need a break or anything, or are we going to push through? Good to go? All right, let's do it. Okay. Turning now to Ohio's Open Meetings Law, this is the Sunshine Law. It's liberally construed to require public officials to take official action and conduct all deliberations upon official business only in open meetings, unless the subject matter is specifically exempted by law. Unlike your technical violations or you didn't follow Robert's Rules correctly, if you don't adhere to the requirements of the Open Meetings Law, then that's subject to challenge under Ohio law in a court that could potentially undo what the action was of the board during the public meeting. So if there is a violation, there also are penalties associated with it. So strictly adhering to the Ohio Open Meetings Act is certainly a priority as it relates to operating your meetings. A meeting means any prearranged discussion of public business of the public body by a majority of the members. If you have 4 board members in a room somewhere and there's a discussion of something relating to the school district that would be subject to the board, arguably that would be considered a meeting of the board that should have been noticed to the public according to your open meetings notification requirements. Should have been published in the newspaper, should have been put on your website. Meetings must be held in person. Under Ohio law, boards of education are required to meet in person. There was during COVID some ability to meet remotely. That's gone away, so meetings must occur in person. A public body, it's a pretty broad definition, is any board, committee, or similar decision-making body of an agency. So again, committees as well as the board itself are subject to the Open Meetings Law and should follow these requirements. Subcommittees as well. So if a board creates a committee, that committee creates a subcommittee, that committee itself should be following the Open Meetings Act. A body established solely by the superintendent is not subject to the Open Meetings Act. So a superintendent's committee, if the superintendent decides the superintendent wants to have a couple administrators explore some item that's been delegated to the superintendent to make a decision on, that's a superintendent committee and not a board committee. It would not be subject, that committee would not be subject to the Open Meetings Act. Even if that committee has a board member or 2 board members on it, that still may be a superintendent committee. It just depends where the directive for the committee came from and the creation of the committee. That being said, if there happens to be 4 board members in your board's instance sitting on that committee, then that would be a committee that would be subject to the Open Meetings Act, because there's at least a majority of board members that would sit on that committee. So it's kind of can get labyrinthine, but it's that's the law that we're working with. Private communications between a board members outside of an open meeting may be found to be deliberations in violation of the Open Meetings Act. So communications by email or text message, if there's a email chain or there's a group text messaging between a majority of the board, or an email correspondence is going between the majority of the board. If that's dealing with public business, that's a meeting that's occurring. Conference calls, so if you have multiple board members, 4 board members on a conference call together, outside of noticing a meeting, that also is considered a meeting. A series of consecutive telephone calls, so if you're playing phone tag and one board member calls the other one, then the other one calls the other one, and ultimately there's a majority of the board that have been discussing this public business through a chain of phone calls, that has been found to be a public meeting. Same thing with face-to-face discussions. If 4 board members happen to show up at the basketball game and you start talking about whether you're going to vote for a building project or a levy, then that could possibly be construed as a meeting. So be aware of those situations to make sure that somebody out in the public doesn't want to challenge a decision or some communications that occurred. Work sessions, workshops, work retreats are meetings when a public body discusses public business among a majority of the members of the public body at a prearranged time. So this is on page 37, by the way. So if you have your organizational meetings, if you have a board retreat somewhere, if you all go down to the Ohio School Boards Conference and decide to have some discussions of public business, notice that you're going to have a meeting. So put it on the record, hold minutes of it. So if there's a possibility that a meeting may occur, there's nothing that says all public board meetings have to occur here. We can have a meeting we hold over in Canton. We can hold one down in Columbus if everybody's all together. We just noticed the meeting. We draft minutes. If you have to have a special meeting somewhere, everybody's going to be in one location. Follow your open meetings notice requirements, and you can continue with that meeting wherever that may occur. Yes?
So, example, board leadership, if the president becomes privy to some information or, say, decides, okay, there's an item that I'm considering, like if she looks over the agenda and she wants to pull an item from the agenda, how could that be communicated just for transparency to the other board members? Because I was understanding from when I got elected in the board training said that you could call like one board member could call 2 board members. But based as I'm understanding what you just said, that can't happen.
Okay. So one board member can call another board member. So you've got a board here. Mm-hmm. You've got 7 members.
Yeah.
If 3 people talk about an item, you haven't had a meeting.
Right.
Once that 4th person gets brought into that discussion, there's a meeting. Are you conducting public business, though? So it's possible that certain situations where, and I don't know the specific instance, if it's discussion of whether we include an agenda item or not, that may not be considered public business or a meeting. I guess it depends what the actual discussions that are occurring are. The board president ultimately, with the superintendent, has the discretion to determine what's on the agenda as well. So the board then would meet. If the remainder of the board felt that this should have been on the agenda, even though it got pulled by the board president, then before the agenda gets approved, you say, we'd like to add this, at the beginning of the meeting, we want to add this to the board agenda. So in that instance, I guess it just depends on how many board members, was it a majority of the board? Was it discussing public business? Was there any deliberation? Those are the types of things that would go into the analysis for determining whether it was a meeting or not. If everybody's on a text chain, or that you got 3 board members on a text chain that talk about something on the agenda, and then that one person from that text chain says, hey, these 2 board members were in support of that, and they bring a 4th board member into that discussion, and this gets challenged and likely is discoverable under by a court, court's probably going to find that was that a meeting occurred in that instance. But again, we would look at it to determine what was discussed. Was it board? Was it public business? Was it how many people were involved? How did all these people get looped into it? And look at it from there to determine whether there's a meeting or not.
Well, one board member still can talk to 2
One board member,
and because it's not a majority.
It's not unless it's a majority. It's not a meeting.
Right.
It's not a meeting. Yep. Yeah, if you bring somebody.
No, I understand if that 3 calls another person, now it's 4, and it's considered a meeting. But I'm saying if it's just if it's just 3, like say.
Technically, it's not a meeting.
It's not a meeting. Yes. I'm gonna just leave it. I'll just leave. I understand. When it becomes 4, it's a meeting. When
it becomes a majority,
when
it becomes a majority, it's a meeting.
It's a
yes.
meeting. Yeah.
Another question. Yes.
Real quick. When we talk about workshops or even trainings where we're not discussing business,
Right.
do they have to still be open to the public? No. So like this training here, we're just doing a training on Robert's Rules. Does this have to be open to the public and recorded?
You would want to, because we're also discussing, and there's some discussion here too. So we decided we were going to have this be a public meeting. If you go to a Pepple and Wagner seminar that we're putting on, and 5 of you show up and you sit in different areas of the room, you probably want to sit in a different area of this room just to so there's some decision that you could say, hey, we weren't meeting together. You don't want. It all depends how somebody would construe it. So, but if you're sitting in on something for informational purposes, there is some case law out there that says that that's not a meeting. So if there's 5 members of the board or 4 members of the board want to go to some seminar and they learn the information, if there's no deliberation that occurs, you have to deliberate. You have to have discussions for there to be a meeting. Just sitting and learning information doesn't necessarily make it a meeting. But there's also some case law out there that says, if you're getting legal information, if you're consulting with an attorney is providing information to you on a specific item, that also would be protected not only under attorney-client privilege, but it's not a meeting if the attorney's just presenting information to you and there's not discussion or deliberation or anything going back and forth. You could probably technically argue that this doesn't need to be a public meeting. We decided to make it a public meeting because this information is, there's no issue in me presenting this information to you. I'm not bringing you any client information. We're not discussing client information or anything that's relating to Akron Public Schools specifically for an action that was taken here. So we decided, just out of abundance of caution, we're going to make this public. So if you all sat here silent and let me talk to you, because you're asking questions and there's some discussions of your specific policies and those types of things, then we felt it was important to make this meeting. If I stood up at that lectern and my presentation was 4 hours long and I just talked the whole time, that's just I'm putting on a legal seminar for you. So, anything else? Okay, so types of meetings: regular meetings, special meetings, emergency meetings. A regular meeting is a meeting held at regular intervals, such as once a month. You have your periodic meetings once a month or every 2 weeks, whatever it may be. Boards of education must hold regular meetings at least once every 2 months, so every 60 days you're required to meet under law. Regular meetings require advance notice to the public of the time and place of the meeting. So your regular meetings, every other Monday, every other Tuesday, whatever it is, every first Tuesday of every month, whatever you set it as. Those regular meetings, just notice them at the beginning of the year. Here's where we're meeting. You don't have to have a statement as to what the purpose of the meeting is. Special meetings are all meetings other than regular meetings, including emergency meetings. Special meetings may be called by the board president, the treasurer, or any 2 board members. Special meetings require advance notice to the public of the time, place, and purpose of the special meeting. So we have a special meeting today. Our purpose of this meeting was having this professional development. That was included in the notice. Whatever the purpose of your special meeting is needs to be included on that special meeting notice. Those special meetings must be noticed at least 24 hours prior to the news media that have requested notice, as well as wherever else you would be noticing your meetings. So there's 24 hours advance notice. Members of a board of education must receive written notice at least 2 days prior to the date of the meeting pursuant to 33-13-16. So if you are calling a special meeting, the public has to know 24 hours in advance. The board members are supposed to know at least 2 days in advance. If not, that board member can challenge that a meeting was held. But if a board member ends up showing up at that meeting, you've waived your ability to challenge that the special meeting occurred. So, that lack of notice doesn't invalidate the meeting if the person actually happens to attend. If, let's say you didn't get the 2 days notice, but you learned last minute, you drove over here, you sat at the meeting, there's no way to challenge it because you didn't receive notice at least 2 days in advance. Emergency meetings. So I guess before I move to emergency meetings, special meetings, you're allowed to go into executive session, but you would want to put on your meeting notice, the board intends to go into executive session for whatever purpose that is going to be. Emergency meetings are something that's noticed less than 24 hours in advance. You notify the media as soon as you know when you're going to meet. You meet. There is no ability to go into executive session during an emergency meeting. It is a specific type of special meeting, so you have to identify in your meeting notice what the purpose of that meeting is. So if the purpose of the meeting is to go into executive session to discuss the sale of property, for instance, you would want to include that in your special meeting notice. If it's an emergency meeting, no executive session. Any person can request notice of meetings. Advance notification includes mailing of the agenda. So an individual has notice of a meeting if they're provided a copy of the agenda ahead of time, if the way that meeting notices are, or they request a notice to be done by mail, they would receive that by mail. If they request it by email, they'd receive it by mail. We're now going to turn to executive sessions. This is discussion of certain information that's considered non-public or confidential for various purposes. At the beginning of this part of it, this is on page 39 of your outline. These are a couple of cases that have come out recently dealing with executive session. They kind of give an overview as to reasons for executive session and why some executive sessions get challenged. Executive session may be conducted only upon roll call vote of a majority of the quorum and only at a regular or special meeting for the sole purpose of considering specified matters that are allowed under law. So again, this is one where roll call vote is required if you want to enter into executive session. The matters that allow you to go into executive session are on page 40 and the top of page 41. To consider one of the following items with respect to a public employee or official: the appointment, employment, dismissal, discipline, promotion, demotion, compensation, or investigation of charges, complaints against a public employee or official. Oftentimes you will see boards say we're going to go into executive session for personnel matters or discuss personnel or discuss an employee. That's not sufficient. We need to know what you're discussing about a personnel matter. Is it an appointment? Is it employment? Is it a dismissal? Are you looking to terminate? Are you looking to discipline, promote, demote, or discuss compensation? So you might be going into executive session to discuss the termination of an employee. You have an employee that's up for termination. They're going to have a termination hearing, and you're going into executive session for that purpose. You're going to want to go into executive session for dismissal or discipline of the public employee in that instance is what you would say. Then you can have that on the minutes. You don't have to identify who the employee is. You don't have to identify by name the employee that you're considering. So that information doesn't have to be revealed. If you do take action to terminate somebody after you've held the hearing, and it determines what your process is under your bargaining agreement, as well as Ohio law, what might be appropriate. If you're taking action then to terminate somebody, that action on the termination would be held in regular session. You would come out of executive session, make that decision, determination, but the discussion of that dismissal, termination, and the termination hearing itself would be held in executive session. To consider the purchase or sale of property, if premature disclosure of information would give an unfair or competitive advantage to a person whose personal or private interest is adverse to the public interest. If you're looking to sell property, if you're looking to acquire property, and you want to give parameters to the administration to determine what you're willing to pay for that property, what you're willing to sell your property for, you can go to executive session. So this is information that you want to come to the negotiation table. You want to get the lowest price you can on a piece of property you want to buy, or you want to sell your property for the highest value you can get. That can be discussed in executive session, but you'd want to identify that as the purpose you'd go into executive session for. Conferences with an attorney for the public body concerning disputes involving the public body that are the subject of pending or imminent court action. So there's a limitation on the reasons you would go into executive session for your legal counsel. It would be subject to pending or imminent court action is what the executive session requires. So you would identify that as your reason if you're going to go talk about some litigation matter, something that's subject to a court case or a pending court case or a prospective court case. Preparing for conducting or reviewing negotiations or bargaining sessions with public employees concerning their compensation or other terms and conditions of employment. So your negotiations, discussions of negotiations, what the board's positions are on negotiations, those are all going to be subject to things you would talk about in executive session. Matters required to be kept confidential by federal law or regulations or state statute. So this is kind of a broad sweeping one. There's a lot of things that would be encompassed in this. If you're talking about students specifically by name, like a discipline of a student, or you're having a expulsion hearing, Ohio law, the state law, FERPA as well, allow for those things to occur. FERPA doesn't allow you to disclose certain student information. You would want to discuss that in executive session. Student expulsions that are being appealed up to the board, those, again, oftentimes would want to be confidential what occurred, so the board would want to have those hearings in executive session. Security arrangements and emergency response protocols of a public body are also, so if you're discussing your emergency management plan, those types of discussions would be subject to executive session. There is no absolute privilege to be accorded to discussions at executive sessions. However, it may be a violation of Ohio ethics law for a board member to disclose what is discussed in executive session. So there is some ethics items that may be implicated by the things that you would discuss in executive session. If they're required to be confidential by statute, such as student information, then statute requires that to be maintained as confidential. So if you reveal that confidential information to somebody, either in the public, your neighbor, then that could be subject to a referral to the Ohio Ethics Commission for consideration. To determine whether something discussed in an executive session is confidential, the designation must be clear, so everybody needs to know that the information is confidential. The designation is warranted by the status of the proceedings or the circumstances under which the information was received. So why did we receive this information? And preserving the confidentiality of the information is necessary to the proper conduct of government business. So I guess turning back to my example on, we're looking to sell a piece of property. We know what our parameters are for selling the property. Let's say one of the board members is a good friend with the person that's looking to bid on that property. Hey, the board's willing to take $550,000 for that property. They leak that to that person. That's a violation of confidentiality. That could be investigated by the Ohio Ethics Commission. So again, this is something that, based upon the circumstances, they would look at to determine whether a breach of confidentiality is appropriate or not. Voting and deliberating in executive session is prohibited, so taking any formal vote in executive session is not appropriate. It could be subject to challenge. Taking straw votes in executive session. Hey, what do you guys think you would want to, we're going to vote when you get out there, just trying to get a feel for the room. That itself would be, if somebody indicates what their vote's going to be, or the whole board indicates what their vote's going to be, then that technically is a violation of executive session and could be subject to challenge. Yes?
I have a question about executive session. So if there's something that you said personally in an executive session, and it's also something that you've said publicly before executive session, does that prohibit you from being able to say that again after executive session? Okay, so we would look at our 3 parameters here. Was the designation clear? If somebody revealed something in public, if it was said in public already, if something was said, disclosed in an open meeting, most likely, if it was repeated again in executive session, the designation isn't clear that it should be held confidential. So you probably don't meet that criteria. Now, it's hard to take back something that was disclosed in open session to then say, well, that was confidential, once you come out, or if it was discussed in executive session. So I would have difficulty saying that there's a way to make that confidential in the future after it's already been disclosed in public. But Follow up,
Yeah.
sorry. But if, let's say, it wasn't at a recorded public meeting, if it was something that, I said to you, and then I had not said to the whole group, but that was the first time it was said to the whole group.
we would look, okay, so was that in, I guess, was something said to somebody in confidence, right? That's, this information was provided to the person to person. Would that person say, hey, don't say this to anybody else, but here's this information that I'm giving you, okay? There's an indication that person wants to maintain it as confidential. Is there a statute that says that information must be confidential or not? That's another, consideration. All these items would be looked at in that context to determine whether they breach confidentiality or not. So if you said something to somebody, I'd prefer you not, reveal this to anybody else. That's when you told it to them. You're not in an executive session. You go into executive session, you go to the board, and you say to the board, I'm saying this to the board only only to these members. I don't want it revealed further. Please don't say this information any further. That you've made the designation clear. A lot of times, this may come up as like medical information or something like that, right? I mean, you disclose something about, I'm dealing with this medical issue, right? Or somebody, or one of the employees has cancer, okay? that may implicate somebody's personnel information that needs to be provided. It needs to have some confidentiality under, Americans with Disabilities Act. Let's say, for instance, it's protected under that. It's only learned through administrative purposes. It's only disclosed amongst the board members for that purpose. There's a possibility that could be considered confidential information. If it's investigated by the Ethics Commission, so on and so forth, I don't know what their decision would be on it, but again, you got to look at the context and you got to look at the analysis for what that would be. So I guess it depends on the situation. So to give you a workaround answer, I guess.
I think I'm confused because she said if she told something to someone in the public, or it's been known in the public, and then comes to executive session and says the same thing, and then goes back to the public and say the exact same thing, is that okay? But would she need to let the members of the board in executive session know that I've already said this to the public, now I'm saying it to you guys, for it to be okay?
No, not necessarily.
Because what we discuss in the executive session is confidential.
A lot of things you discuss in the executive session would be confidential, are confidential, or should be maintained as confidential.
Right, but we as members of the board, if we hear it on the outside and it was said at the executive session, we don't know that it was already communicated on the outside. So would that board member have to say, hey, I already said the same information to people on the outside, but I'm telling you guys too, so that we're not misled when we go out in the public and we hear the same thing we discuss in executive session.
So if somebody's already been out in the public and said something, right, that's already occurred, okay? Mm-hmm. And then the person in executive session says, I've said this to, whatever it is, made a public statement about it, told, a myriad of individuals about it, and you tell the board then what the information is. I don't think it's confidential information because it's already been disclosed out in the public previously. Right.
But if the board doesn't know that? So I'm saying, like, when you talk out in public and you come to executive session and say something, shouldn't the board be notified, like, hey, I've already given this information out, so we don't think when we step out and see community that it's confidential?
It would be a courtesy to tell your fellow board members that, I've already said this, I've already committed this, I've already, put this on the record, right. Whatever that may be. I mean, certainly as a courtesy, so somebody doesn't get blindsided when, say somebody in the media comes to you and asks for what your opinion on it is because the other board member already said something about it, right? So in those situations, as a courtesy, it certainly would be helpful to know that information. I don't think there's any directive that it's required, but that's kind of part of board professionalism and working together and that type of thing. In that situation, it would be, yeah. Good decorum, good courtesy, good way to handle it. Okay. Turning now to page 42. In presenting a motion for executive session, be specific. So the act requires a specific statement of the applicable open meeting exception. So go through, here's your exceptions. Be as close to what the statute says as possible when you're saying the reason for your executive session. If the matter concerns the appointment, employment, dismissal, et cetera, of an employee, use that specific term. Don't just say personnel. The act does not require the name of the employee to be stated, and exceptions are narrowly construed. If you happen to be in executive session, you went into executive session for whatever that purpose is, then you start talking about other items of public, interest, public concern. Your executive session discussions should be confined to whatever the purpose for you entering executive session is. Even if you said, let's go into executive session for discussion of the appointment of an employee, but then we get off track in executive session and start talking about collective bargaining. Even though that would also be covered under an executive session topic, when we went into executive session, we didn't tell the public that's what we were going into executive session for. So you then violated what your purpose for going into executive session is. So if you're going to talk about appointment of an employee and collective bargaining and sale of property, list all three of those at once and go into executive session. You can talk about all of them right then and there, but but make sure you cover yourself as to what the executive session topics are and don't get off of those topics for what you went into executive session for. If a board member begins discussing in open session matters that should be discussed in executive session, another board member may consider raising a question of privilege under Robert's rules. Let's say, for instance, you start talking about some items that we got up on collective bargaining. We're going to start talking about what our authority is for health insurance. We're willing to go 80-20 on health insurance, something like that. You've just revealed your position for collective bargaining to the public. Another board member can interject and say, we shouldn't be discussing bargaining topics that haven't been settled upon at this point. Let's talk about that in executive session. I'm going to raise a question of privilege under Robert's rules, and then we go through that process to make sure that gets discussed in the appropriate forum, which would be executive session and not in open session. So executive sessions, we spend a lot of time on them because they are important. There are reasons for why we need to have those things confidential and maintained amongst the board. Violations of the Sunshine Law. Any action taken by a public body while that body is in violation of the Sunshine Law is invalid. So a court will invalidate things that are done in violation of the Sunshine Law. There's times where boards then will, if the action was taken, the board would be prevented from taking that action in the future. The board, a court could say, this was in violation of the Sunshine Law. We're going to invalidate what that action was, and any additional attempt by the board to try to take that action again to try to cure that would be invalid also. There is a case out there dealing with some redistricting that occurred among a school district. A decision was made outside of the Sunshine Law where some redistricting occurred. The Board of Education took action on that redistricting. There wasn't an appropriate meeting on it. The board invalidated that. The board then went and tried to hold another meeting to take the same action. The court found that invalid because it never in the first place should it have occurred. So be careful with taking actions or doing things that go outside the bounds of the Sunshine Law. If a person believes that a public body has violated the Sunshine Law, that person may file an injunctive action in the Common Pleas Court to compel the public body to obey the law. If an injunction is issued, the public body must correct its actions. So you go back to the status quo. You might have to put something on the record saying that, pursuant to this case, this resolution is rescinded, may have to pay court costs, and must pay a fine of $500. Whichever party loses the lawsuit is also responsible for reasonable attorney fees at the other party to the extent ordered by the court. So a court can, in its discretion, award attorney's fees to a litigant that challenges a board action and is successful. A member of the public body who knowingly violates an injunction imposed for a violation of the Sunshine Law may be subject to further court action and removal of that individual from office. So again, we go back to that, reasons for removing a board member from office. That would be dereliction of duty. So there is a possibility to remove. So that's the Ohio Open Meetings Act implications. With the remainder of my time, and I'm close to being done, I'm turning to page 46. On page 43 through 45, these are some guidelines, some things to look at on your own. The functions of a Board of Education, boardsmanship, things to consider for being an effective board member. These are all published by the Ohio School Boards Association, I like to keep them in here just as a refresher, but although I don't really go over them. We've gone over a lot of these principles throughout this process, but it's nothing that we need to really hit on today, so feel free to read those at your leisure. Last thing I want to cover is ethical considerations and prohibitions, and a lot of this deals with that confidential information we were talking about and what could come about if you reveal confidential information, as well as when conflicts of interest occur in voting. So the purpose of the Ohio ethics law is to protect the public from financial, family, or business conflicts of interest of its public servants, and to prevent a public official or employee from using the authority or influence of their position for personal gain. So we're talking about when should a board member abstain, when is there an ability to, or the basis for abstaining from taking board action on something or voting for board action. The three most common implications with board members are a public official cannot secure a public contract for himself, a family member, or a business associate. A public official cannot have an interest in profits or benefits of a public contract entered into by a public agency with which he or she is connected. A public official cannot profit from a public contract the official approved or that was authorized by a body of which the official was a member unless the contract was competitively bid and awarded to the lowest and best bidder. So we can't take action to benefit a family member, a business associate, or yourself. We shouldn't be voting on contracts for either me to provide services to the Board of Education, a family member to provide services to the Board of Education, or hiring of a family member. Those are appropriate times to abstain from that type of that type of vote that's in front of the board. If one board member's son or daughter is being considered as a teacher in the district, please abstain. If there's discussion in executive session about that employment or appointment, you don't even participate in the executive session. Walk out. Don't even be there. Put it on the record that you're not in that executive session. If there's a possible conflict of interest where there's something that you could receive as value or a family member can receive as value, if your son, daughter, somebody that you're in business with is looking to have some sort of business, be a vendor of the school district, remove yourself from any of those discussions, deliberations, and especially the vote. Don't advocate for them to get a contract with the district. Don't advocate for them as a business, those types of things. Abstain from the vote. Don't participate in the discussion or deliberation. That's covering when abstention should occur and when they're appropriate. The next one we're talking about is ethical prohibition against disclosure of confidential information. So again, Robert's rules suggest that a board, certain things that are handled in executive sessions should be confidential. Executive sessions are confidential in certain aspects for certain reasons. So revealing that confidential information would subject an individual to investigation and possible charges through the Ethics Commission. Ohio ethics law prohibits current and former public officials and employees from disclosing information that is confidential. It remains in effect so long as the information remains as confidential. So if you've learned something during your tenure as a board member, you're no longer on the board, but that information remains confidential, it should not be disclosed even after you no longer serve on the board. For school board members and employees, this means that confidential information obtained during an executive session of a Board of Education meeting is not to be disclosed. And again, we go through that three-item analysis to determine whether it's confidential or not. Is it designated to the public official as being confidential? Because of the status of the proceedings, is it confidential? And is it necessary for the proper conduct of government business to maintain that as confidential? Those are the three criteria that we look at. Turning to the last page of my outline, revised code 10299, a disclosure of confidential information is considered a first-degree misdemeanor. Imprisonment a punishment could be up to 180 days in jail and a fine of up to $1,000. So again, rarely are board members challenged on this, but most board members will keep things confidential that that are considered confidential and are aware of as being confidential. So best practices for ethics concerns. So this is when you're abstaining or dealing with confidential information. Determine whether there are prohibitions of the ethics law that apply before taking any action. Determination after the action taken is too late. So if you did vote in favor of something that you find out that there was a conflict, you can't really go back and unring the bell. Determine whether information discussed in executive session is considered confidential. That concludes my presentation. If there's any questions, I'm open to them now, but I appreciate you having me here twice to go over this information. Hopefully, this has gotten you some guidance to help you run meetings that are going to be more efficient, that follow the requirements of both your policy, the law, Robert's rules, and I appreciate the board and the administration for having me, the ESC of Northeast Ohio, which actually put me in contact with you. And if any questions come up, feel free to contact me. Ruth has been great with communications. If you have questions that come up afterwards, she's a good resource. She can get them to me. I can get you an answer pretty quickly, or any of my colleagues at Pepple and Wagner, or your in-house legal counsel as well. So thank you again.
Yeah, I do have one question, Mark. When you talk about abstentions, if you weren't at a board meeting and you had to vote on minutes, you can abstain from that. You should abstain, correct?
Yes.
Okay, because that wasn't mentioned. I wanted to make sure.
If you can't certify what happened at a meeting or,
Right.
or what occurred at a board meeting, then you are in your right to abstain. That being said, to pass minutes, you got to have a majority. So we need to have a majority be at the next meeting that can support the minutes. Otherwise, we're going to have to postpone that decision on the minutes until the next meeting. So
Thank you, sir.
thank you very much.
So I actually had
yeah.
a question
Yeah.
about the minutes while we're on that topic, just quickly. So when it comes to corrections or additions, is that generally done by vote or just if there's no objections by other board members, they're just accepted?
Okay, so at the beginning of your meeting, you open up passage of the minutes, right? That can be done informally. So does anybody have any corrections, additions, technical changes? That's open to the board. The board member can then speak up, say what the corrections are. The remainder of the board can hear that. If there is no objection, there is a method through Robert's rules that if nobody objects to whatever that change is, then it's basically approval by not responding, basically. So that change can occur, and there wouldn't need to be a formal vote on making that change. Then still you would want to make those changes prior to adopting your minutes. So have that on the record that this paragraph needs to be changed to say whatever, and then change will be, and then you would approve your minutes after that. You wouldn't want to approve your minutes and then say, oh yeah, I found this in the minutes, this needs to be changed. Then you'd have to open, because you've already passed that action, then you'd have to have another motion to reconsider approving your minutes. And then you'd have your deliberations, discussions, what were the changes that are going to be, and then you're going to vote on that to then change your minutes. So let's make the changes prior to actually approving the minutes.
Thank you. And I think I also read, although I know this board does it, you don't have to vote to approve the minutes. You don't have to motion.
Okay, so there is a law dealing with reading of minutes and approval of minutes. You should approve the minutes. There is a law that allows minutes to be adopted by operation of law if there isn't a formal vote, but it's good practice. It's recommended that minutes do get approved by your board so that there is an official record.
Thank you. And so if there's no other questions, thank you, Attorney Jackson, for sharing your knowledge with us and helping this board, again, be the best version of itself. With that being said, we will entertain a motion to adjourn. Is there a motion?
So moved.
It's been moved by Member Sykes. Is there a second?
A second.
Seconded by Member Hall. Is there any discussion? Seeing none, roll call, please. Mr. Alexander?
Oh, Ms. Hall,
Yes.
Ms. Jackson,
Yes.
Dr. Molnar,
Yes.
Mrs. Sykes,
Yes.
Mrs. Autry,
Yes.
Mr. Alexander, yes. We have 6-1. I'm sorry, 6-6. I'm sorry, 6-6. Gee, 6-6. I'm sorry.
6-6.
Yep, 6-0. 6 or shit. 6-0. I'm sorry.
Thank you. We are now adjourned at 7:26 p.m. Thank you.